A person at the jail, please state your name for the record.
Derek Bailey.
This is the case of the people of the state of Michigan versus Derek James Christensen Bailey, case number 26-100-FY. We're here for an arraignment. Sir, you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes.
I have a complaint that alleges that on or about January 9th, 2026 in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of possession of methamphetamine. That is a 10-year felony and or a fine of $15,000. Additionally, the prosecution has elected to charge you as a second or subsequent offender, meaning that you have at least one prior drug conviction in your past. That makes that 10-year felony a 20-year felony and the $15,000 fine up to $30,000. In count number 2, it's alleged that you committed the offense of police officer assault, resist, and obstruct. That is a felony punishable by up to 2 years in prison and or $2,000 in consecutive sentence may be imposed if it happened in a place of confinement or arising out of the same transaction or occurrence as another charge. The prosecution has also elected to charge you as a habitual fourth offender, meaning that you have at least 3 either attempted or completed felonies in your past. That would make that 10-year possession of meth felony a life offense, and the 2-year felony for the resist and obstruct a 15-year offense. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request the appointment.
All right, court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 99 an attempted resist and obstruct, in 2000 an attempted financial transaction device uttering and publishing, in 2002 B&Es with intent, in 01 a no account check, in 01 uttering and publishing and an attempted uttering and publishing, 05 unarmed robbery, in 15 possession of marijuana, in 20 a snowmobile failed to wear a helmet, false ID, driving the license suspended on a snowmobile in flee 4th, in 20 there's a retail fraud 3rd, and also a possession of meth and resist and obstruct. It's also my understanding that Mr. Bailey is on bond in the circuit court and was remanded this morning due to a bond violation. The praxis scores him at a risk level 7. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor, I do realize and respect this is largely academic for the most part due to that remand, but I would ask the court to consider still issuing a bond in this matter, preferably as low as the court could. I know the court mentioned some concerns there, but for all we know, the circuit court issue may resolve before this one. I would like to see this defendant being able to realistically post a bond if possible. He is between jobs, so very low income, no substantial savings, but he does have strong long-term ties to the community, lives here in Cadillac. I don't doubt would gladly stay in the area, obey all bond conditions. He's aware that this type of a charge, this type of an allegation would most likely require random drug testing. He would capitulate with that and any non-monetary bond conditions that were wanted to place. Thank you.
I believe he also has a parole hold on him, if I remember correctly.
It's definitely possible.
Ms. Lawrence?
Thank you, Your Honor. I do have limited information. I don't have a report yet. I do know that this was a methamphetamine pipe. It was full of white and color residue that did true narc test positive for methamphetamine. He essentially tried to discard this evidence when officers were trying to arrest him. He also tried to run. I think given the fact that he was on bond for the same thing when this occurred, it goes to show he is not a good candidate for bond. I do understand he has a remand, so it doesn't, I guess, necessarily make a difference in this case, but I would still ask for a monetary bond of $50,000. This is some pretty serious felonies and not his first time with methamphetamine. He did also admit to smoking methamphetamine earlier in the day, so I would also ask the court to impose random drug testing. Thank you.
Thank you. Give me just a moment. I'm looking at the probable cause affidavit. Okay, I'll also note that the praxis indicates that he has, pursuant to judicial warehouse, has 7 failed to appears in the defendant's past. I believe one of the issues with bond is that he had left a treatment facility in violation of his bond. So I do find, based on the 7 failed to appears in the past, the fact that the defendant is charged with a resist and obstruct and has convictions for resist and obstruct in his past, I find that the defendant is a flight risk. Bond will be set at $25,000 cash surety with the following conditions. Mr. Christensen Bailey, you are to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. I'm also ordering that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for those. Next arraignment.
Your Honor,
Yes.
I do apologize. I would also request the court to impose a no contact order with the co-defendant in this case.
All right. I am going to also order that there be a no contact with Laura Webster. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. If you are found to be in violation of your bond, you could be arrested without a warrant and brought back to jail and have your bond revoked. Yes. Thank you, jail. Next arraignment. A person at the jail, please state your name for the record.
Crystal Marie Schwarz.
This is case number 26-98-FY. The people of the state of Michigan versus Crystal Marie Schwarz. Ma'am, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
Did you meet with somebody from the Public Defender's Office today?
Yes, sir.
I have a complaint that alleges that on or about January 8th, 2026 in the city of Cadillac or Wexford County, it is alleged in count number 1 that you committed the offense of police officer assault, resist, and obstruct. That is a felony punishable by up to 2 years in prison and or a fine of $2,000, and consecutive sentencing may be imposed in certain circumstances. In count number 2, it's alleged that you were a disorderly person drunk. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. The prosecution is also elected to charge you as a habitual 4th offender, meaning that you have at least 3 prior either attempted or completed felonies in your past. That makes that 2-year felony a 15-year felony. Do you understand those charges and the potential penalties?
I guess.
Do you understand that with the information that the prosecutor has, that they have elected to charge you as a habitual 4th offender, and that you've been charged with assault, resist, and obstruct? That's a 2-year on its own, but once that habitual 4th gets added, it becomes a 15-year felony. And then the disorderly drunk is a 90-day misdemeanor. Do you understand that?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
The public defender.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove two things. One, probable cause that the crimes had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecutor is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 04, I showed domestic violence and abuse. In 07, an operating while intoxicated. 08, domestic violence. 08, operating while intoxicated. 09, domestic violence second. And 10, a retail fraud third. 12, a driving while license suspended. 13, an attempted resist and obstruct. 15, resist and obstruct. 16, tampering with electronic monitoring device as an attempt. In 17, an assault and battery. 17, an attempted resist and obstruct. 18, a resist and obstruct. 19, a domestic violence. 19, a resist and obstruct. 24, domestic violence and disturbing the peace. And in 25, a disorderly drunk. The praxis scores her at a risk level 2. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor, and I do respect that this is felony accusations. When I met with her this morning, the reason why she made me look a little bit confused, the jail sheet doesn't always have the prosecutors can do. And I do advise people that that may be a possibility, but just so the court was aware of why that was going on. What I will say is she does have in the court moral support her husband, who she was expecting to be here, and he does plan to support her throughout all these proceedings. He has advised me that he is sober himself, and that if she is able to get a bond, he will help her in maintaining her sobriety. That is a bond condition. We presume with these type of allegations, it will be. I advised her this morning, and she advised me that she would obey random testing, whatever the court wanted to do with that. In fact, I don't doubt if the court were on the fence about higher monetary bond or daily testing, that she would even do daily testing if that was the issue. I did hear on her past some things involving alcohol, so I would understand if the court or the people had that concern. But she and her husband are both low income. He works in the paper delivery industry. I don't know if Your Honor's ever done that, but it's a lot of labor, not a lot of pay. So even though he has a lot, they're wealthy in love, but not in money, I guess is what I'm trying to say there, Your Honor. So I would ask the court to consider perhaps even more than usual bond conditions in lieu of any significant monetary. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. I am going to ask for a significant monetary bond in this case. The defendant was highly intoxicated. The initial call was at the party bar. The defendant was threatening to kill and stab a waitress. Staff said they essentially had to push her out of the building and lock the door because she refused to leave. Following that, she went to the Chris gas station and essentially was causing the same problems there. After that, officers arrested her. She was banging against the partition in the patrol vehicle. She was threatening to kill officers. Between North Mitchell Street and the jail, she managed to get one of her handcuffs off. And when the door was opened, she lunged at an officer, essentially like she was going to strike him with the loose cuff that she managed to get off. I think not only these facts alone, or allegations, I should say, her criminal history clearly shows that she is a danger to the public. These are not her first RNO charges. These are not her first disorderly charges. I'm making an assumption here, but I'm assuming this probably has a lot to do with maybe a drinking problem. But still, there is clearly a concern for public safety here. So I would ask the court to impose a $50,000 cash surety bond, as well as daily alcohol testing in this case.
Did they do a PVT on her at all?
They did not, Your Honor.
All right. The court does find that Ms. Schwarz is a threat to the community for a few different reasons. One are the number of domestic violence in her past, the number of resistant obstructs in her past. At least as alleged here today, she made threats to kill and stab a waitress, to kill officers, actually got out of her handcuffs and allegedly lunged at an officer when the doors were open. So I do find that she is a threat. Bond will be set at $25,000 cash surety with the following conditions: that peer is ordered to keep contact information current, not leave the state without permission, and to commit no new crimes. I'm going to change that $50,000 cash surety. Not to consume any alcohol, be subject to random testings, not to act any threatening, intimidating, harassing behavior, not to purchase or possess any firearms or weapons. Next arraignment, please.